Yes, my lords here present, Leonard Silks, senior colleagues, distinguished members of the bar, and attendees of this webinar. Thank you for joining us again on another episode of the Tech Law webinar series organized by the Tech and Law Committee of the Nigerian Bar Association section on legal practice. My name is Damilola Victoria Alabi. I am the coordinator of the session, and I have very delectable Huloma Okoro will be moderating the session today. So Huloma, please, the floor is yours.
Okay. Good afternoon, Leonard Silks, Leonard colleagues, and everyone here present. I'm very pleased to be moderating this section, and I'm very sure that many of us will find it very rewarding. So before we start, I would like to introduce our guest for today. I'll be reading her profile. She's here with us and is going to take us through everything that we'll do today. Let me get her profile ready. So with us, we have, please forgive me, we have Mrs. Ibukunoluwa, or Miss or Mrs. Sorry. My apologies. Ibukunoluwa.
It's Miss. Thank you. Miss.
Okay, thank you very, very much. And sorry for that oversight. So Ibukunoluwa, CIPP, is an experienced legal professional specializing in data protection, emerging technologies, and international arbitration. Her career journey spans over a decade, working in leading law firms in Nigeria, London, and Hamburg, where she worked in dispute resolution and international arbitration. Building on her private sector experience, she transitioned to public service, now serving as the head of regulations unit at the Nigerian Data Protection Commission. In this role, she's at the forefront of shaping Nigeria's data protection landscape through regulations, policy implementations, investigations, stakeholder guidance, and compliance education. She's passionate about the intersection of data protection and cross-border disputes. She also serves as the Secretariat of the Regulatory Harmonization of Data Protection Laws across Africa under the Network of Africa Data Protection Authorities, NADPRA, RAPDP. Is a working group led by Nigeria. Her commitment to regional collaboration is further demonstrated through her role as the Secretariat of the Anglophone Committee of NADPA, RAPDP, where she supports the president of the committee, the National Commissioner and CEO of the Nigerian Data Protection Commission. Her recent contributions include serving as the Secretariat of the recently issued Nigerian Data Protection Act, General Applications and Implications Directive, 2005 Drafting Committee, and contributing to and editing a white paper on Nigeria's data management ecosystem, launched at the NADPA RAPDP 2025 conference. Welcome, and we're very, very glad to have you on our midst this afternoon. Thank you so much.
Thank you.
Thank you very much.
Yes, and welcome once again, Ms. Ibukunoluwa. So before we proceed, please, so on behalf of Fernandez Marcus-Obiene, the chair of the Tech and Law Committee, I want to welcome everyone to yet again another session of the Tech Law webinar series. And I can see, we have, the room is getting filled. That shows the enthusiasm, that shows that we have been delivering value over time. Thank you very much for trusting us. So a few instructions, please. The CPD link for this webinar will be shared in due course. So there'll be no need for you to drop your email, Supreme Court number, year of call, or any personal detail in the chat box. Please, these are your personal details. We will not be needing them. Also, with respect to the CPD link, when the link is shared, please, the link will only be active for the duration of this webinar. After the webinar, the link will no longer be active, and questions and inquiries about the link will no longer be entertained. So please, when we share the link in the course of the webinar, we'll reshare over and over again. Kindly fill while the webinar is still on. Thank you very much for that. Also, as we always emphasize in all our webinars, that will enjoy our participants to get familiar with the NDPA SLP AI guidelines. That is literally like the Bible as or the guiding rule, the constitution of the Tech and Law webinar series. You can download this on the NDPA SLP website. And for the paid participants who are here, who are yet to be members of the NDPA SLP, do join us. I mean, this and many more are what you stand to gain by being a member of the section on legal practice. So once again, you're welcome. Now, quickly, before Mrs. Ibukun goes into our presentation, we have a poll that I will be launching now. The poll will only be on for 2 minutes. Is our way of gathering information so that we are making data-informed decisions so that we can serve you better in this knowledge sharing series that we hold from time to time. So the poll will be on your screens for 2 minutes. So please fill the poll so that we can collect this information. Ulama will coordinate the poll. So I'm launching now. Yes, so the poll is on. You should be seeing the poll on your screen now.
All right, thank you, everyone. Please just take a few minutes and fill it for us. It also helps us coordinate and get relevant information about what everyone needs. So please just take your time. It's showing on your screen. Please, if you can't see it, also let us know. It's about 7 questions, 1 minute, and it should be done. Thank you. We're already seeing the answers coming in.
Yes, thank you. So to those who are just joining, if you're wondering what we are doing or what's on your screen, we are taking our usual SLP Tech series poll. So please fill the poll. I mean, in about a minute, the poll will be out of your faces. So thank you. Yes, we're seeing the information. Please fill the poll, please. So yes, the first question is, what's your year of call? The second, have you ever used an AI tool in your legal work, e.g. for research, drafting, analysis? The third, which legal task do you think is most suited for AI support in Nigeria? The fourth, would you trust an AI-generated analysis in advising a client on the likely outcome of a case? Fifth, what is your biggest challenge with adopting AI tools in your legal work? The sixth, in 5 years, AI will have what kind of impact on Nigerian legal practice? And the last question, which AI have you used in law practice? So in 30 seconds, the poll will be ending. Thank you to everyone that has filled and still filling the poll. Thank you. So we're counting down. Yes, 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Thank you, everyone. So I will end the poll now. Yes, so from the poll results, we can see that 21% of the participants are between 1 to 5 years post-call. 6 to 10 years post-call is 20%. 18% is for 11 to 15 years post-call, and 16 years post-call and above as the highest. So we have very senior members of the bar on the call, and that's very encouraging, actually, that we have more senior colleagues than the younger ones. And then, have you ever used an AI tool in your legal work? 40% says yes, regularly. 38% occasionally. 8% I've tested, but I don't use it. 14% is saying no. Which legal task do you think is most suited for AI support in Nigeria? 63% legal research, 18% drafting contracts and pleadings, 17% document review and due diligence, 3% compliance and risk analysis. The fourth question, would you trust an AI-generated analysis in advising a client on the likely outcome of a case? 5% is saying yes, fully. 57% is saying yes, but with my review. 24% is saying maybe, depending on the case. 14% no. Question 5. What is your biggest challenge with adopting AI tools in your legal work? 31% lack of knowledge or training. 15% cost and access to tools. 8% poor infrastructure on internet. 43% ethics or professional concerns. 6 In 5 years, AI will have what kind of impact on Nigerian legal system, legal practice, pardon me. 43% is saying transformational. 48% significant but limited to certain tasks. 8% minimal, the system won't adapt quickly. Okay, and 2% saying negative, more risk than benefits. Question 7, and the last. Which AI have you used in the past in legal practice? 66% ChatGPT, 11% Gemini, 4% Claude, 3% DeepSeek, 15% others. Thank you so much. So over to you, Uloma.
All right, thank you so much, everybody. And then I can see that there were some people who were not able to fill the poll. Sincere apologies. I'm sure there'll be other opportunities, but we just wanted to, it doesn't contribute to your CBD score. We just wanted to use it to get an experience of what our colleagues will, or what our opinions are on the subject. So without wasting much of your time, I will lead the floor to our distinguished speaker to take us through today's session. Thank you very much.
Hello, everyone. Good afternoon, Leonard Silks. Good afternoon, senior colleagues and fellow colleagues. Thank you very much for inviting the Commission to this webinar. It's very dear to us as it's one of our strategic pillars, which is awareness. So we're very happy, and lawyers are very key to driving compliance in this space. So this is a very, very important topic and session for us. I'm hoping that Damilola would share.
Yes, I'm doing that right away.
Okay, thank you very much. The National Commissioner, Dr. Vincent Olatunji, sends his regards, and he's very, very happy about this session. So once the slides are up, we will start. I am hoping that it would be interactive in a way. I know that most people cannot turn on their videos, but please feel free to use the chat box, because I will ask some questions when we go into the scenario part of the session, and I will appreciate answers. I just want to make it as interactive and engaging as possible. Thank you.
Okay, let me know when you can see my screen, please.
Yes, I can see Damilola. Yes. Thank you very much. I think we can go to the first page, the second page, actually, learning outcomes. Okay. Thank you very much. So I would be speaking on data privacy impact assessment, which is an exercise that companies, organizations, people dealing with data are expected to conduct when there is high risk to the data processing activities. I'm going to assume that most people know about data protection here, and most of the terminologies that I'll be using are already familiar, but I will still try to explain some of it. But if there's any particular terminology that I use that you're not familiar with, you can just put it in the chat box and I will try to quickly explain. Because if I decide to start speaking on foundational data protection principles, I don't think we'll have enough time for that. So please just bear with me. So by the end of the session, you would understand what a data privacy impact assessment is, what is the reason for it, what are the obligations under the Nigeria Data Protection Act and the Nigeria Data Protection Act General Application and Implementation Directive regarding it, how do you conduct one, what are the steps to conducting one, and then after conducting it, what are the next steps that organizations, companies, and people controlling data should take. So just to know that personal data is any information that can be used to identify you directly or indirectly. So for example, your name, your NIN, your passport number, your BVN, your home address. Please note that. The next page, please. Okay, great. The Nigeria Data Protection Commission, we are the apex regulator for regulating personal data processing. The two principal laws that we use are the Nigeria Data Protection Act 2023, which I'll be referring to a lot today. And then we recently issued a regulation in March 2025. It's called the Nigeria Data Protection Act General Application and Implementation Directive. So what that regulation does is that it provides further directives and clarifications on what is already in the Act. it would take effect from September, and then we'll start full-on compliance and enforcement in relation to it. So I'll be referring to these two principal laws as I go through this session today. So what is a data privacy impact assessment? It is an exercise that is conducted to assist organizations to identify and assess data protection risks. Under the Act, that's under Section 28 of the Nigerian Data Protection Act, companies are expected to conduct a DPIA when your processing will likely involve in risks to high risks to the freedoms of data subjects, high risk to their privacy rights. We have now gone further in the NDPA Act to define what high risks mean. And that means that if you're conducting processing that can lead to identity theft or fraud, or a situation that would highly impact an individual's privacy, you will classify that as high risk. So if you sit down and think of your processing activity, and just know that processing means any action on data. So whether that's storing data, whether that's altering data, whether that's saving data, whether that's collecting data, any set of action on data is processing. So if you think of your personal activity, for example, if you think about the fact that I'm hosting an event today, and based on that, I'm going to be collecting the names of all the people that will be coming for the event, I will be taking their numbers and I will be taking their email addresses. That is a processing activity. So if based on the way we have defined high risks and just based on general knowledge, you believe that there might be some risks to the privacy of these people, then you have to conduct a data privacy impact assessment. So it's a very in-depth tool that allows you to really sit down and consider what your processing activity is and how to identify the risks to privacy that may occur from this activity, and then think of measures. So what can you put in place to address these privacy risks that you have identified while conducting your DPIA? Sorry, Damina, can you move it up? I'm not seeing the full page. All right, yes. So it is a proactive tool. So under Section 28, you are expected to conduct it before you go ahead to do that processing activity, so that you can be able to note what the measures in place are, and you can be able to put those measures in place before you actually conduct that processing activity. It's also important to note that when you are introducing new technologies, you are expected to conduct a DPIA. And when you are introducing new processing to an already complicated existing processing activity, you are expected to conduct a DPIA. So like I said, it's a legal requirement under Section 28 of the NDPA Act and also under Article 28 of the NDPA Act Guide. Damala, we can move now. Done with this page. Okay. What is the purpose? So like I said before, is to identify, assess, and mitigate the risks to the rights and freedoms of individuals that may arise from a new project, system, or process involving the processing of personal data. And it should be conducted before the commencement of data processing. We can move on. Okay. Okay. So I've already referred to Section 28. I won't spend much time on that. We can move on. Okay. And then Article 28 as well, which also talks about a DPIA. Yes. All right. Can we move on to the next page? Yes. All right. No, I think, okay. Let me just, I think I might just use my own slides here because it keeps moving. Okay. All right. Like I said, Section 28 is the section that deals with what a DPI is, or expressly provides for what a DPI is. And then Article 28 now goes further. So what we have done in Article 28 in Guide is that we have now provided specific instances when a DPI will be required. So these are instances that, based on data protection and processing, they would normally result in high risk to processing activities. So we have now gone ahead to list these particular instances. And one of them is Damala, can you go further down? Okay, yes. So when you're processing results in evaluation or scoring, so for example, now there are certain customer activities in telecommunication companies that would classify certain customers as high value customers, and also in the banks as well. That is profiling already, and generally that is considered high risk processing. Automated decision making as well, because it usually leads to legal or similar significant effects. We classify it as high risk processing. Under the Nigeria Data Protection Act, Section 37, automated decision making is allowed, but it's only allowed in instances where there would be human. There are certain companies that will use automated decision making to conduct recruitment processes. However, that particular process must have some form of human oversight within that process for it to be able to qualify under the Act as automated decision making that is allowed under the Act. The next one is systematic monitoring. Another high-risk activity is when you are processing sensitive or highly personal data. Sensitive data has been defined under the Act and is generally biometric data, any data that has to do with your health, political opinions and affiliations, and then some other instances provided for under Section 65 of the Act. When personal data processing relates to vulnerable data subjects, that's also a situation that will classify as high risk. Vulnerable data subjects has also been defined in the NDPA Act guide, and we have provided instances where people will qualify as vulnerable data subjects in relation to health, financial situation, data and digital illiteracy. Another high-risk instance is when you're deploying innovative processes or applications. Another high-risk instance is financial services involving possession of personal data through digital services. So this mostly occurs within the banking sector. Another high-risk processing is healthcare services. Another one is cross-border data transfer. And these are all things that when we're going through the scenario, you will see them come out in practice, and then we'll be able to discuss them further. Another high-risk processing is deployment of surveillance cameras in places that may be accessed by members of the public. So there are certain instances where governments will be allowed to do this under national security reasons. But when private organizations are doing this, we always insist, and it's also an obligation under the law, that they must do this with safeguards in place and with adequate notice and consent to the data subjects. So these are all the instances that we have listed in the NDPA Act guide that will require a DPIA. However, if you go back to the general definition, this list is not exhaustive. So if your processing will still result in high risks to the rights and freedoms, which is basically to the privacy of data subjects, then you will still have to conduct the DPIA. We only just provided this list to make it easier for people to be able to understand when a DPIA will be required. But like I said, it's not an exhaustive list. And you always have to go back to the definition in Section 28 and Article 28 of NDPA Act Guide. So in simple terms, there is a diagram here that explains when a DPIA will be required. So you have to ask yourself, does the project involve personal information? If yes, will the project involve a change of way in handling personal information? If yes, is there a potential to high privacy risks? If yes, if all these answers are yes, then you have to conduct a DPIA. But if no, then it's not likely required. Just also know that in the Act as well, there is an obligation that when you conduct a DPIA and you're done conducting it, but you believe that you haven't been able to identify measures in place that would adequately address the privacy risks, then you have to consult the Commission to discuss the DPIA, and then we'll be able to provide guidance and direction as to how to go about it. A DPIA is expected to be vetted by a DPO and also signed by a DPO as well. So a DPO is a data protection officer under the Act, under Section 32. All organizations that process data are expected to have data protection officers. And their major role is advising companies as to how to comply with the data protection laws and regulations in the country. So generally how a DPIA works is the DPO is expected to be the one to initiate the process of a DPIA, But there are certain instances where it might be the project manager or legal or compliance, because generally lawyers will know about this because data protection also falls under compliance to a certain extent. But in practical terms, it should be a DPO that should initiate it. However, you see that in certain instances and scenarios, there might be other principal officers that will initiate it. But the task of vetting it and also signing it off has to be done by the DPO. All right. So Section 28 of the Act now provides 4 major steps to conducting a DPIA. The first one is a systematic description of the processing, considering its purpose, its context, and its nature, and the legitimate interest pursued by the data controller, processor, or third party. So like I said, when we go through the scenario, you will see how this plays out in practice. The next step is now for you to conduct an assessment of the necessity and proportionality of the processing, which basically means that you have to really sit down and think, why do I need to conduct this data processing activity? Am I using as much data as I need, or am I using less than I need? And am I using more than I need? And then you also now consider the amount of data that I'm using. Is it proportionate to the benefit that I'm actually trying to achieve? Like I said, we'll all discuss this when we're going through the scenario. After that, the next step will now be for you to sit down and think of the possible risks that can occur from these data processing activities. For example, identity theft, fraud, unauthorized access to data, and some other risks that we'll also see when we go through the scenario. And then the final steps will now be thinking of measures that you can put in place to address those risks that can occur from your data processing activities to ensure that data subjects' rights are well protected. Right. So we'll go through each one here. The first one is the systematic description. In conducting this particular exercise and answering this particular question, you would ask certain questions like what personal data will be processed? So what are the types? Are we talking about employee data? Are we talking about health data? Are we talking about patient data? Are we talking about financial data? What is the sensitivity involved? You then ask, who are data subjects? Are they employees? Are they customers? What are their categories? What are their vulnerabilities? Women, the female, these are things that you would think of. Then why is data being processed? So you think of the purpose. What is the reason for actually taking on this data processing activity? And what are the objectives for that? The next question will be, how will it be processed? So will it be automatic? Will it be manual? What will be the technology that will be infused or used to process this particular data? The next question you ask is, where would data come from and where will it go? So how am I collecting data from data subjects? After I collect it, where is the data imputed into? What database is it going into? What artificial intelligence system is it going into? And what would that system how will it interact with that data? The next question would be, how long would that data be retained? What are the storage principles and laws in place that I'll have to comply with? I am so sorry about the noise in the background. I'm at another event representing the committee, and I had to just step out for this webinar. So please just bear with the background noise. The next question will be, what is the legal basis for each processing? So under the Nigeria Data Protection Act, we have provided 6 bases under the law within which companies can process data. The first one is the infamous consent, which I'm sure everybody's familiar with. The second one is contracts. The third one is legal obligation. And that's where there is a law that actually expressly provides that you can conduct a certain processing activity. For example, now, the FIRS Act provides that FIRS officials can process your data for tax purposes. You also see the same with the Labor Act as well regarding employment. So that's legal obligation. And public interest is when you process it for the public. And you mainly see this happen regarding government officials during their government activities. And then maybe for public interest, like during the COVID-19 situation, when the Center for Disease Control actually had to process people's data for public interest to be able to give people information as to how the disease is spreading and what they need to do. And then we have vital interest, and that's mainly done to mainly done relating to health services to be able to bring people back to life or resuscitate them. So for example, you have situations when someone is unconscious, but you need to protect their data to be able to treat them. And then the final one is legitimate interest. And that basically has to do with the processing data for the company's benefits. It's something that you will see a lot of big data companies relying on, like Meta, Twitter, for them to be able to process data, but it's highly scrutinized because sometimes they rely on this as a way to process data when they should actually be relying on more stringent legal bases like consents and contracts. And then the final question is, who would have access to this data? So when you're answering this particular question, these are the sub-questions that you will need to consider in answering it. The next one is assessing necessity and proportionality. And the major reason is to determine if your processing is necessary and if you're taking proportionate measures to actually proceed with this processing. So key questions that you will ask is my processing necessary for the stated purpose? So for example, now, a bank that intends to open an account for an individual, you can ask for you can ask for their name, you can ask for their phone numbers, but you may not need to ask for other certain information. For example, now you may not need to ask for social media accounts. And I know, since I'm on the call with lawyers now, you may know about the decision involving CBN, where the court held that banks can actually take your social media information for KYC. And that's something that at the commission, we actually contest that, because you actually really need to explain to data subjects as to why you need that for certain banking services. So that's where necessity comes in. You have to really think that you should only take data that is needed for a particular purpose. And that's where data minimization comes in, which is a very core principle of data protection. You should only take the minimum amount of data that is needed for a particular processing. The next question would be, are there less intrusive ways for me to actually conduct this processing? So can I do it with less data? And these are things that, like I said, will show up in the scenario. The next question to ask is the processing proportionate to the benefits gained? So you have to think of, why am I conducting this processing? And the method I want to go about it, is that what I need to be able to get this particular benefit to ensure that it is proportionate? Does the benefit outweigh the risk to data subjects? Have I put in adequate safeguards so that data subjects are well protected? And data subjects are people like you and me that own our personal data. And then the last question under this particular question regarding the DPIA assessment is, are there alternative approaches that will achieve the same purpose? So can I use security measures like anonymization and pseudonymization? The next one is for you to now identify the risks to data subjects' rights and freedom. So we have listed risks here, examples of certain risks. We have unauthorized access or disclosure. We have loss or dispersion of data. We have alteration, inaccuracy of data, lack of control, leading to the inability of data subjects to actually exercise their rights under the Act. You have discrimination and bias. When you're using automated decision-making, this is a really huge risk. And so it's very important that you really sit down to think about how your algorithm sometimes can lead to biased decisions. Then another risk is surveillance and monitoring. When it's excessive, it can actually be a huge interference with people's privacy. The next one is reputational damage from public exposure of sensitive data. The next one is financial loss, identity theft, fraud, and then physical harm. So those are the list of certain risks that can occur, but there are way more than this, depending on the particular context that data processing will be done. And the final one is measures to address this risk. So we have technical measures, which are the particular tools that you would put in place by they will mostly be implemented by the IT teams. And then you have organizational measures. So for technical measures, you have tools like encryption, pseudonymization, anonymization, which is where you use certain words to so for example, instead of putting somebody's name, you use asterisks to write that so that people cannot actually see their names. Access controls. So we always advise that organizations should have very detailed access controls policy to ensure that only certain people that need to process particular set of data actually have access to it. There is secure coding, there is intrusion. there's DLP, data loss prevention, and there's privacy by design and default. So that's for technical measures. And then you have organizational measures. And that really has to do with policies, procedures, and standards in place, like your privacy policy that tells data subjects what you do with their data, consent management systems, staff training, incident response plans that deals with data breaches and how to respond to them in a very effective way. You have DPIAs, data protection agreements that would ensure that your third parties actually comply with the act as well to ensure that data is well secured and managed and used in a responsible way. And then regular audits. So those are the 4 main steps that companies have to conduct when they're conducting a DPIA. After conducting a DPIA, we always advise, and it's also mentioned under the law, that you should conduct a reassessment, particularly when you are going to be infusing a new processing method, or just after a year, just to conduct an audit to see whether there may be new risks that you may not have identified when you conducted the initial DPIA. It's also important to note that under the NDPA Act guide, in instances where you're obligated to conduct a DPIA and you choose not to, or you do not do that, and the commission finds out, we can issue a directive. Actually, we can issue a directive stating that your platform should be restricted for a particular while, and this has huge negative, significant impact on your businesses. So it's important to note that as well. So like I said before, a DPO is expected to sign off on your DPIA, and they're expected to keep your DPIA within their records. There are instances where we investigate companies and we ask for their DPIAs to see whether they actually conducted one, to be able to identify measures in place to protect data. So when to review? Periodically. When there are also significant changes to your processing operation, we advise that you review, and in certain instances also mandated under the Act. When there is a data breach, security, or incident regarding that processing activity, you're expected to review your DPIA and update it to ensure that new measures are now put in place to protect data. And then when there are new regulations or legal guidance issued regarding certain processing activities. So different parties in an organization play certain roles and responsibilities in the DPIA process. The key parties are generally the data protection officer, the product team, so people that actually develop this product, your legal and compliance team, because they generally will direct you, they will tell you what the law is and direct you to where the law is, and then exactly state what the express provisions are under the law regarding conducting a DPIA. And then senior management, because you realize that a lot of exercises or actions that you have to do after conducting your DPIA, you will need senior management to sign off on it. So they're very key in the whole process. So a data controller, who is the person that would decide what to do with certain data, and this will come out with the scenario, would be the one that will be responsible for ensuring that the DPIA is conducted and that the recommendations are implemented. Like I said, they have to sign off on certain recommendations and actions resulting from a DPIA. The DPO is the one that would advise on the necessity of a DPIA. The DPO will also monitor its performance, ensure that they work with all the relevant departments in an organization to ensure that the DPIA is actually conducted and that the recommendations resulting from it are actually implemented by the organization. The project manager at times would initiate the DPIA and will also provide detailed information. The product teams would provide a lot of information that would end up going in DPIA, because they will be the one explaining the processing activity, the technical side to the DPO, and they would also be the one that will implement the security measures that have been recommended. So I think I've already touched upon this. IT team will provide technical expertise, legal will advise on compliance. And then there are certain instances where you might actually need to speak to a data subject to really understand the risks that could occur from you taking their data. So sometimes you might have limited perspective on the risks that could occur. So you have certain instances where you might need to discuss with data subjects that would be affected by that processing as to the risks that can occur. And they actually may be able to provide valuable insights and potential impacts that would also feed into your DPIA. So in conclusion, the DPIA is generally to proactively identify, assess, mitigate high risks to the fundamental rights and freedoms of data subjects. And when we say fundamental rights, in this concept, we mean your rights to privacy under Section 37 of the 1999 Constitution. It's a blueprint for responsible innovation and sustainable growth. Because what it helps you to do is that it really helps you to really sit down and think of your person activity and think of it in a way that is very detailed and thorough, so that you ensure that as you're building and innovating, you're also putting the necessary measures in place to avoid data breaches and to protect data subjects. It's not a one-time checklist, so it's not something that you just do and you forget about. You have to continually check it. Sometimes you may need to check it in 6 months. So for example, now big data companies that are conducting data processing on a regular basis and they're churning out this on a regular basis, they would need to continually review their DPIA, maybe like every 3 months, every 6 months, to be sure that there is no new risks that can occur that they have not identified. So it's an ongoing commitment, and it should evolve as data processing and solutions evolve. By conducting and implementing measures identified from a DPIA assessment, we build a future where data processing and innovation thrives hand in hand with human rights and public interest. So thank you very much. That is the presentation. Please let me know if you have any questions before we go into the scenario session and then fill in the NDP Act Guide DPIA template. So sorry, I forgot to mention that we have, under the NDP Act Guide Schedule 4, we have provided a template which all companies are expected to use when conducting their DPIA. So the scenario that we're going to review now would actually be done hand in hand with that particular Schedule 4, that particular template. So you can see what the Commission is expecting when we ask for a DPIA, and then you can also see how it works in practice.
Okay. All right. Thank you so very much. Please, if you have any questions, just like she has said, please drop it in the chat and then we'll read it out so she can answer them. We just need a few minutes for this so that she can go over to the next part of the presentation. Thank you. Please just drop your questions in the chat. We'll be reading them out. I know that a number of people have asked for the slides, and we've also responded that a recorded version of this session will be available on our YouTube channel, the MBA SLP Tech Committee YouTube channel. The link later.
Okay, so
Sorry.
Okay, please go ahead. Please go ahead.
So I wanted to ask how you want to go about it. Are you able to put the scenario and the template side by side? Or is not?
I'm not sure I'll be able to do that.
Okay, I guess put the scenario then. Put the scenario. The template has already been sent to the participants, right?
Yes, we sent it.
I would just go through the template here, and then you can just put the scenario on the screen because we'll probably be referring to it a lot. Thank you.
Okay. First question we have is, we have this question from Ibukunoluwa, and he's saying, please, are we to submit the DPIA form after performing the exercise to NDPC?
No, not every time. So under the Act, when there's a situation where you conduct your DPIA, but after conducting it, your measures, the measures in place that you have identified, you don't really believe that they will be sufficient enough to address the risks that you have identified, then you have to submit it to the Commission for guidance. So in instances where you conduct your DPIA, you've identified your risks, you have identified measures in place, and you are confident that those measures would actually adequately address the risks you've identified, then no need to submit to the Commission. But if it's the case that you are not sure, then you have to submit to the Commission for discussion and guidance. However, you should always have your DPIA in your records, because like I said, in investigations is something that we always ask for, because it's a way of also showing accountability as well. So even if we're not asking you to submit it every time, you actually have to conduct one and put it in your records. And then another thing to note is that when you approach the Commission for approval of cross-border data transfer, one thing we always ask for is your DPIA. So just to know that even though you may not submit to Commission every single time you conduct it, it's important to conduct it, implement the measures in place that you have identified, and then keep it within your records for when that time comes that you may need to submit it to the Commission.
Okay, sorry, we'll just take two questions wrapped in one before we continue so that we don't take much of your time. The two people are asking, how do we get DPO certification, or how do we qualify as DPOs? And then we see people complain about not receiving the templates, and I'm sure this will be taken care of. But the main question is about getting the DPO certification.
Okay, the DPO certification, that's a good question. So this year, the Commission launched a national certification program for DPOs. The first batch was held in January, where we trained people for over a week, about 500 individuals, and then they took exams 3 weeks after. And last month, we certified 438 data protection officers. So that's the first batch. However, and that was sponsored by government, so there wasn't any payment. However, the next batch would be starting later this year. Information is not out yet. We don't have specific information on when to start it, as the department is still working on that. But emails have been sent out regarding that. How that will run is that we have DPCOs, and those are data privacy compliance organizations. They are organizations that the Commission licenses to carry out compliance services on our behalf. So we have law firms that are DPCOs. I'm sure that there's some of them on the call. We have IT firms, we have audit firms as well. They would conduct trainings for data protection officer certification exams. And then thereafter, the exam will now be conducted by IIM, that's the Information Institute Management. When that process is finally in place, there would be information regarding that on our social media pages, and I'm sure emails also be sent out to people that are already on our database. So it's just to look out for that.
Thank you. We have a number of questions. Please, I'll take them at the end of this session so that we
Yes,
don't please just look at the chat for how to satisfy the CPT points for this session. Please look at the link shared in the chat and fill the form attached. Thank you very much.
Thank you. So let me just confirm when you can see my screen. I'm trying to display the scenario.
All right, great.
So can you see my screen?
Yes. Okay, all right. So I'll quickly read through it and then we'll just go into it. But I just want to be sure that you all have the templates, because it will really help you to understand as we go through it.
So apparently, because I also received the mail, I think from the admin, there was a bit of an error. The mail was sent and an attachment was mentioned, but I think a correction has been sent. So people should just check their mail. They will need to download it. So a new mail was sent. The first mail that was sent, apologies for that, it was not attached, but a new mail was sent. And in that mail, you have 2 links for downloading the scenario and for downloading the template. So please check your mail again. There's a mail, you have a mail from the MBA SLP to this effect. Thank you.
Okay. I think we can also try putting it in the chat box, the PDF of it.
Okay, so let me download and then look for that. So I think I'll just
go ahead while you try to sort that out. Thank you very much. All right, so our scenario today is Melo's cloud migration. Please imagine yourselves as data protection officers at Melo, a major telecommunications provider operating primarily in your country of residence. We'll call it country A today. Melo has a large customer base and possesses a vast amount of personally identifiable information and other sensitive data, also known as personal data. The information technology and business development teams have a new strategic initiative to migrate Melo's core customer relationship management suite from on-premises servers, so that's physical servers located in the place, to a new cloud service provider, CloudServe. This migration is intended to improve operational efficiency, scalability, and reduce IT cost. So the key details of the project are as follows. Can we move up, Damlola, please? Thank you.
Okay. My network is
No worries. I'll just pull it up from my screen as well then. Okay. So key details of the project are A, system to be migrated. That's CRM suite, the customer relationship management suite, is a critical application that holds a wide range of personal data for all customers, including customers' names, addresses, phone numbers, email addresses, financial information, billing and service usage data, call logs, communication history, customer service notes, and marketing preferences and consent records. So that's A. B is the new cloud service provider, CloudServe. It's a well-regarded cloud provider. This is examples of this in actual practice are AWS by Amazon, Azure by Microsoft, that. Its data centers are located exclusively in another country. We'll call that country B. Country B has data protection laws that are different from country A. While country B's laws provide some protection, they are not considered adequate by country A's regulatory body for the possession of sensitive data and just general personal data as well. The next detail is data transfer. The migration will involve a one-time transfer of all historical CRM data, followed by continuous real-time data synchronization. That's the third detail of the project. The fourth detail of the project is that new technologies would also be integrated post-migration. The first one being an artificial intelligence-powered customer segmentation. And what this plans to do is to implement an AI model developed by third-party vendor, Insight AI, to analyze the migrated CRM data for advanced customer segmentation, churn prediction, and personalized service recommendations. The artificial intelligence will also perform further processing on existing customer data, inferring new attributes such as high-value customer and at risk of churn based on usage patterns and demographic data. The second new technology would be a blockchain for consent management. And this blockchain would enhance transparency and immutability of consent records, as Melo intends to store all new customer marketing consent decisions and their timestamps on a private blockchain managed by a consortium of telecom providers. This blockchain is designed to be irreversible for auditing purposes. The specific blockchain technology chosen for consent management system is relatively new, and the long-term support and maintenance roadmap from its developers are not entirely clear. There is also a lack of absolute assurance that this technology would be supported throughout the projected 10-year life cycle of the CRM system. Finally, project timeline. The project is an aggressive one, with the migration scheduled to begin in 3 months. The project lead has identified this project as a low-risk infrastructure change and is pushing to bypass certain compliance steps to save time. Your task as the DPO is to use this scenario to conduct a comprehensive DPIA training, a comprehensive DPIA for Melo's intended migration involving legal, IT, and senior management. So now we'll go on to the Schedule 4 DPIA template. So before I start, based on this scenario, why do we think that a DPIA is necessary?
So participants can, you can indicate your answers in the chat box. And if you check the chat box again, for those who are probably having a difficulty locating the template and the scenario in their email, I have attached both documents in the chat box. So if you check, you can download from there and open straight away on your device. Thank you. So you can answer the question. We can get your responses from the chat box.
Okay. Yes, that's one. Any other reasons? If you can remember the list from NDPA's guide where I listed certain specific instances where a DPI is supposed to be conducted. Thank you very much. Cross-border data transfer. Any other reason?
Can I?
Yes, please go ahead.
Okay, somebody's answering. Data has been moved across different platforms.
Yes,
oh, high-risk customer. Okay.
Yes.
Okay.
Blockchain, yes, that is also an emerging technology and quite advanced.
Okay, a vast amount of.
There's one I'm looking for that.
Oh, somebody said sensitive data, personal. Okay.
Very good, thank you.
Yes, sensitive data.
There's still one more I'm looking for that I haven't seen in the chat.
Likelihood of risk.
Yes,
Okay.
yes. So that's a general one, yes. Remember the integration of new technologies.
Technology, yes.
Migration. Yes, there is one new technology that I refer to that actually
AI. Somebody mentioned AI.
Exactly. Perfect. Okay, great. So we're all in agreement that this particular scenario actually requires you to conduct a DPIA, right? Great. So I think now everybody should probably have the template because I'm going to run through the template now. So the first question that you would have to answer on the template is you have to highlight the central work of MELO for protecting personal data and the major reasons for carrying out the DPIA. So before you even talk about the DPIA, you would first describe MELO. So I already said that MELO is a telecommunications company, very major one in country A. So you would describe what they do and their whole processes. That can take like 2 or 3 paragraphs because we as regulators, we really, really need to be able to have all the information to ensure that we're able to make informed decision-making regarding your processing activities. So you have to describe that. Then after describing that, you would now have to talk about the particular activity you're trying to do, and then your reasons for conducting a DPIA. So is there anyone that wants to try that as to how you would describe this based on the scenario? Okay, anyways, there's no time, so I'll move on. The answer is actually already in the scenario, which actually already explains that they would like to move their customer, the CRM suite from on-prem to cloud service providers. So they want to do that for scalability and efficiency as well. So that is how you would describe it. But you also have to describe the fact that even after it's being moved, there would now be some new technologies implemented post-migration. So that's the artificial intelligence that would be that would be implemented as well as blockchain for consent management. So these are things that you would have to describe extensively in that. Oh, great. Thank you very much. When you're answering this particular question. And it's important to note that we have now provided assessment columns where we actually would ask you whether or not you believe that the information you've provided is adequate enough. And we have a scale of 0 to 10, 0 meaning that you don't really think it's adequate, and 10 meaning that you believe that the information you provided is sufficient and you're very, very sure that this is the actual information required for you to be able to conduct a comprehensive DPIA. So flowing from that, the next question will now be the nature of the envisaged processing. And that takes us back to, if you remember the 4 steps I mentioned, the first step regarding a systematic description of the data processing activity, considering the nature, the scope, and the context of the processing activities. So, Dama, if you can move up, please, that would be great. Thank you very much. Okay, no, up. Yes, exactly. So the next question is, will data be processed automatically? Based on what I already explained, I think we already know the answer to this. Yes, you're moving data from on-prem to cloud services. That's already an automatic processing. So the simple answer to that is yes. But if it's manual, you include manual there. The next question is, what specific areas or types of data would be processed? So the answer is actually already in the scenario. We spoke about customer data, personal data, financial data. Those are the sort of answers that you would include in this particular section. The next one will be the next question is, who would this data be about? That's already in the scenario as well. Customers. They will be about customers because the particular suit that you're actually trying to move is a customer-based relationship management suite. The next question is is there a risk of this processing exceeding the intended scope? And that's something that it's the particular organization in question that would answer. One thing you realize is that when products are being developed and they're then tested in the market, there are certain instances where, based on how the market interacts with the product, organizations want to add certain new processing activities or levels to it. to enhance it or to make it more efficient. But those are things that you have to sit down with the product teams, senior management, and legal teams as to whether or not it's something you envisage in the future. And if that's the case, then you have to impute the answer here. And also examples of setting processing that may exceed the intended scope. Okay. If you notice here, when we spoke, the part of the scenario that speaks about artificial intelligence, there's a part that talks about wanting to profile people as high profile customers and that. Certain organizations may want to use that particular information to also benefit them. So they might think, okay, if we identify someone as a high profile individual, what sort of services we want to offer them to ensure that, you know, we're able to make more profit from that. And that can actually lead to a different business activity. So that is something that you have to consider here. And the next one is, would any third-party companies be involved? I would want the audience to answer this based on the scenario. Third-party processors that will be involved in this based on what the scenario. Who are the likely third parties that you think? Good. Yes. Good. Who else? Good. Yes, exactly. That's the AI Insights company. Good. And then there's one more. So the block, thank you very much. Okay. So based on this scenario, those are the three obvious ones. But in practice, there probably be way more third-party providers that might actually be involved. So just to note that. The next question is, would the processing involve sending data to other countries? The easy answer is yes, and I'm sure you all already know that country B. If data is transferred to another country, what legal justification exists for this? So this is where cross-border data transfer comes in. And if you look at sections 41 to 43 of the NDPA Acts, you will see what the express provisions are regarding that. But the general rule under the Act is that you are not supposed to transfer data out of Nigeria without getting the Commission's approval. We're very aware that we're in the education stage, so not a lot of compliance is done in relation to that, but that is the law. And if the Commission finds that you're in breach of this, then we'll find you in violation of the law. So the general rule is that you cannot transfer data out of Nigeria. That's general rule. Without getting approval from the Commission, there are different ways to get approval from the Commission. The first is through an adequacy decision, and this will involve the Commission. This would involve you submitting your application to the Commission. We will then review where your data will be going to see whether or not they have adequate safeguards in place. And we have 4 key things that we look at when we're looking at this. We look at whether or not that particular country where data will be transferred to, whether they have an adequate data protection law in place. That's one. We also look to see whether they have an independent supervisory authority, for example, the Commission, that is able to enforce the laws. We then check to see, do their laws have enforceable data subject rights? The next step is we then check to see, are there redress mechanisms in place? So do they have court system? Do they obey the rule of law? Do they have independent authorities that you can take your complaints to, just like the Commission? And then finally, are they subject to any international commitments or conventions that will ensure that they actually comply with data protection laws? For example, now, Nigeria is a party to the Malabo Convention on Cybersecurity and Data Protection, which already put some obligations on us. You also have the ECOWAS Convention on Personal Data Protection, which Nigeria is also a party to, which already put some obligations on Nigeria as well regarding data protection. So we'll check to see whether all those factors are actually in place where data will be transferred to before we'll now consider giving you or providing an adequacy decision. And once you get that, you can transfer data with the Commission's approval. That is one step. The next way is through cross-border data transfer instruments. We have binding corporate rules, we have code of conduct, we have certification mechanisms, and then we have standard contractual clauses. I won't go into that because of time. And then finally, there are now derogations under the Act. So where you cannot get an adequacy decision or a CBDTI, you can now rely on certain instances like where you told data subject about it and they have given you consent for that. But I won't go into that. That's a whole lecture for another day. Yes, so in this particular section, you would be answering whether or not you have an approval from the commission to be able to transfer data out of Nigeria. The next one is to consider the processing method and the data types and what are the potential risks. I already went through like a list of possible risks that can occur when I was giving the presentation. You have identity theft, you have fraud. You can think of the scenario and think of other risks that can actually occur as well. So we'll go on. The next one is what specific types of data will be processed. This is very similar to the second question that we already answered, but this one is asked for you to provide it in more granular detail, like names, email address, instead of you just saying employee data. That's the difference. Then the next question is how many people will be affected by this processing? Most times you may not be able to estimate how many people will be affected by the processing, but you may not be able to get the accurate number, the actual number of people that will be affected. But we always ask that you provide an estimate, and you can do this by thinking of similar situations where that similar processing activity has occurred and how many people were affected by it. And this is very important because it's something that we use to actually gauge the risks that can occur. So if you're placing data of a lot of people, that's already high risks already, because that means that if there's a breach, it can affect so many people, and that's already high risk to the processing activity. So that's for that particular section. The next one will now be the lawful basis for processing. So we ask that you state what the lawful basis is for processing. Can the audience tell me what they think the lawful basis will be regarding this particular scenario? I went through the six lawful bases when I was presenting earlier. So
someone said legitimate business interest.
Legitimate interest, yes, that's one. Yes, that's one. Any other one? Consent, very good. And I wanted you to bring out consent, particularly regarding direct marketing. If you look at where they speak about AI, they intend to also direct and profile people and also advertise certain things to certain individuals, which is direct marketing. And the only legal basis for you to do that under the law is through consent. So yes, consent. Some contract as well, exactly. So contract will also come into play as well. So those are generally the three legal bases that probably would feature most in this scenario. But when you're answering this question, you also have to describe what are the reasons for you relying on this legal basis. You can't just write it there. And then if you have prior relationship with data subjects, you should also provide that in this particular instance. So that's for legal basis. Now, the next one we'll be looking at is necessity and proportionality. So this is where you would actually explain why you have chosen this processing method and what you would be using to achieve this. So what type of data you're using to achieve this, and why those certain types of data are necessary for you to achieve your purpose, and why it is proportionate to your intended goal. So that's something that you probably have to sit down deeply with the product team, with the legal team and senior management to really explain necessity and proportionality. In the scenario, we already see that they explain that they would want to do this for efficiency and for scalability, but then they also have to really consider whether or not they need to move it to a cloud server that is in a country where data protection laws are not as stringent or as developed as the country where you're moving data from. So those are things that you have to consider when you're thinking of this particular question. You can also consider things like, do you need to use the blockchain technology as well? Are there other ways for you to manage consent records and keep records without using blockchain technology? So, and do you also require artificial intelligence to be able to enhance the experience of some of your users and provide direct marketing services? So these are things that you would have to consider and answer when you're answering necessity and proportionality. Then you also have to think proportionality. Do you believe that the data you're collecting is proportional to the benefit you're trying to achieve? Is it excessive? Is it enough? Do you need as much data as you're taking to be able to do that? So you can look at the scenario and the different data sets that we had already identified, both customer data, financial data, and all of that. The company will have to really sit down to think, do we need this much data just to be able to move our CRMs to cloud service providers? The next question would now be, you would answer is, you have to explain how it directly allows you to achieve your goal. You would then have to explain how you would keep data secure and respect people's privacy. I already went through some of the tools that you can use to keep data secure, so I won't spend that much time on that. But in also answering this, you also have to think about data subject rights as well. What are the measures you put in place to ensure that if data subject rights are being affected, it can be remedied? Then the next question is, mention practice in common in democratic society for data protection. If you remember when I was describing cross-border data transfer, I said that there are certain factors that the Commission will look at in granting an approval for that. Those are democratic practices. So applicable data protection laws that are enforceable, independent supervisory authorities, international commitments and conventions that particular country is subject to, enforceable data subject rights, and remedies in place for data breaches. So those are examples of, so you have to sit down and really think about whether or not that country you're transferring data to actually has all this in place. Then the next one is, you have to consider whether or not you have thought of alternative methods that would be less intrusive. So, and that's where data minimization comes in and proportionality comes in, because you really have to really sit down and think as to whether or not you can achieve the same purpose without using as much data or taking as much data, or actually using a certain type of technology now. And in this sort of instance, we'll consider the blockchain that is being used. One thing about blockchain is that it's irreversible, and there are reasons why people actually use it, because you are able to easily prove that a certain thing happened at a certain time. However, because it's irreversible and you can't delete data on it, it may affect data subject rights to deletion. So how do you deal with that particular instance where a data subject wants to delete certain data, but because it's now on the blockchain, they're not able to do that? So you have to think of, are there less intrusive ways to do that? And one of the ways you can consider doing that is it's, in addition to the blockchain, having a database on site that actually has all the actual data, and then what is on the blockchain is one that has been pseudonymized or tokenized. And you can then use that particular data to match it with the physical data on site. And that way, if a data subject decides to exercise their right data deletion, you can delete their data on the database, and then the one on the blockchain actually remains. Because the one on the blockchain is pseudonymized, there's no risk to their, anonymized, there's no risk to their privacy rights, as nobody can see it, and it won't lead to any data breaches. So those are sort of instances that you would think of in relation to how can I consider alternative methods to ensure that the data processing is not intrusive, or that certain instances that will lead to data breaches have already been remedied or taken care of. So that's for that particular question. The next question is, explain why the other methods that you have considered are more effective in achieving your legal purpose. If you want to still go ahead with the blockchain solution, then you have to explain why it's the best decision for you. An example can be that, like I already said before, the data is not deletable. So for all these purposes, it's very good. If you have regulatory issues, it's easy for you to prove using records from the blockchain. So the next one will be consultation with stakeholders, and general stakeholders are the Nigerian Data Protection Commission, as by the regulators, data subjects that are taking data from, the internal manager, so that's the data protection officer, the senior management, and product and IT teams. The next session would be the identified and potential vulnerabilities. So right in this particular session, you would think of different risks that can occur and the effect of it on data subjects regarding data confidentiality, integrity, and availability. And then when you're actually considering risks, you have to think about the likelihood of the risks occurring and also the severity as well. So I've already gone through certain different types of risks. There's no time anymore, so I won't spend a lot of time on that. All right, but I think I still have a bit of time. So I wanted to just ask, based on what I have said, what do you think the risk is in relation to cross-border data transfer to another country where they don't have strict laws in relation to personal data protection and sensitive data? What do you think that risk is?
Let me check for responses. Identity theft. Somebody said identity theft.
Okay, yes. That's possible. It's not
unauthorized
the
access.
I'm looking for. Yes.
Fraud.
Yes, okay. Yes, okay. But it's not direct answer I'm looking for. So I'll give you a scenario. There was a time at the commission where something similar to this happened, and the jurisdiction where the particular organization decided to transfer data to, their laws in place state that data can be transferred to countries from that particular country without any approval from the commission. So basically, where they intended to move data to, the laws there state that you can move data across borders without any approval from the commission. And the danger with this is that if that is in place, there is no regulatory body to actually check where data will be moving to. So that means that, let's say country A is Nigeria now. So Nigeria now moves it to country B. And the organization later on decides that they want to move that data from country B to another country. And there is no regulatory body checking to see where that data is moved from country B to, whether there are adequate safeguards in place. So whether they have laws that are enforceable, whether they have exercisable data subjects' rights, whether they have an independent authority. So that means that if something happens to my data now that has been moved from Nigeria there, because my data is there, I would have to probably consult that particular country's laws or their independent authorities to exercise my data subjects' rights. But because there are no strong and strict laws there, then I'm not able to exercise those particular rights. Because one thing I said about data protection is that the laws are very jurisdiction-based. So if you look at Section 2 of our Act, it states that the Act applies to data protection within Nigeria. And this applies to citizens that are here and people that are not Nigerians that also live in Nigeria. It's the same way if you go to other European countries, that's the same way, that's the same law that applies. So it's limited to jurisdiction. But if you take my data to another country where they don't have enforceable laws, and then maybe I experienced something like identity theft and fraud now, it will be hard for me to complain to any authority or to exercise data subject rights that I can actually exercise in Nigeria. So that's why the commission is very keen on ensuring that whenever you're moving data across, we have to look at the agreements in place to ensure that certain measures are in place, to ensure that there are adequate security measures, to ensure that where data is being moved to actually respect data subject rights and their laws and adequate redress mechanisms in place. So just to note that so that you can understand the importance of cross-border data transfer. There's also, exactly, to be easily breached, yes. There is also the risks that can also occur from using artificial intelligence. One thing that artificial intelligence does is that, yes, it is good for efficiency, but if the model is not well trained or if it's trained on limited data sets, it can lead to biased decisions. It can lead to disparate outcomes that were not intended. So now that the Mello is deciding to use artificial intelligence, there's a risk that if that model is not well trained, or if it's on limited data sets, it may actually lead to discrimination or bias. So those are things that you would have to consider when you're thinking of the risks that can occur. Now, when you're thinking about the risks, you have to now, under this template, you now have to go further to think of the degree of the risks that can occur, and then the likelihood of the risks actually occurring. So when you're thinking of the degree, we have provided for, which is remotely, is there a low chance that it will occur? The next one is possible. Is there a possible chance that it will occur? The third one is probable. Is there a probable chance that it would occur? So when you think about all this particular different degree of risks, you have to really sit down to think of, is there a remote chance that the risks that I've identified will occur? And in doing that, you have to think of, am I processing sensitive data? If you are, then most likely it won't be remote. It will probably be possible or probable. And that's because sensitive personal data already had the high risks attached to it. So when you're processing it, if there will be a breach, there's a likelihood that there will be a breach. It's not going to be remote. So remote mostly would occur when data has to do with nominal data, so like name, email addresses, nothing too serious. If person will be on a large scale, it's not likely to be remote because those numbers would already envisage that there's a high risk that will be involved. If you're using artificial intelligence, it's not likely to be remote because, like I said, using of AI comes efficiency as well, but there's also bias involved in using AI, except you're training the models very well and you're using diverse data sets to ensure that this does not happen. And then you're also putting the adequate safeguards in place. So privacy notices, security measures in place, and telling people what the data will be used for. So remote is generally used when you're processing nominal data that doesn't involve sensitive data and is not involving a large number of people. So in this instance, I would not say that the risks that will occur will be remote because there's so many instances that are already triggering high risk processing. The next one is the next degree is possible. So that's where maybe there are certain instances where you might need ultimate credential for authenticating valuable transactions. An example of this is the use of biometrics to authenticate transactions. There is nothing like that is being used here. However, because of sensitive data and because of the use of artificial intelligence, I would say that there's a possibility that the risks that have been identified can actually happen as well. And then the last one is probable. And that means that you're also using decisive or ultimate credential, and you're using some complex measures and processes in place, like the use of artificial intelligence and blockchain as well. These are the things that you consider in deciding the degree of the risks that can occur. Then after now deciding that, you will now look as to the likelihood and the severity of the harm that can occur. So we have, under the template, we have marginal or low. So that means that is there a low chance of it actually occurring? And like I said before, because it doesn't involve sensitive data, so there's a low chance that it will actually occur, then you now tick low there. Is there a significant or moderate chance that it's actually going to occur? And when you're thinking about the use of artificial intelligence, blockchain, some sensitive data, in those particular instances, there may be, if that risk actually occurs, there is a significant harm that can occur to the data subject, so that you pick that. And then grave or extreme enormous really, really happens when you're processing personal data on a large scale and the risks that you've identified are quite significant. Then there would be a grave or enormous chance that it will likely occur. Right. Then the next one is you would then consider how this might intersect with other data subjects, right? And this is where we talk about potential disparate outcomes. And when it's something that really, really occurs when you're using artificial intelligence, like I said, AI allows for efficiency, but it's also something that, if it's not well used, can lead to disparate outcomes that were not intended, like bias or discriminating against a certain certain group of people. So in this particular instance, when Melo is using artificial intelligence to be able to classify some particular customers as high-paying customers, high-value customers, and also to market certain things to them. And there are certain instances where that may actually lead to discrimination regarding other customers that will not be able to get the same certain benefits that the high-value customers may be able to get. So in that sort of instance, that is something that can lead to a disparate outcome. The next session is cross-border. I know that we only have 5 minutes left, so I'm going to just rush. The next session is cross-border data transfer. I've already discussed this to an extent. You would answer whether data will be transferred out of Nigeria. You would then answer whether there are specific countries, in this case, country B. You would then identify the legal justification. Like I said, adequate by the commission or a cross-border data transfer instrument. After that, you would then consider the laws in place to ensure that we're transferring data to is actually adequate. So independent data protection authority, enforceable data subject rights, the rule of law. You would then mention whether or not citizens have the same rights in those countries, and just go back to my scenario regarding moving data from Nigeria to country B and the certain implications that can occur from that because of country B's laws are not as strong and as adequate as country A's law. You then have to also talk about instances where there have been systematic discrimination against vulnerable groups. That would consist of doing some research regarding where you're taking that data to. And these are things that at the commission, when we're trying to review this, we're very interested in, because it can actually impact whether or not we would grant your approval, or whether or not, if we bring you in for an investigation and we see that these were things that were already identified in your DPIA, but you still went ahead to proceed without putting the adequate measures in place, that can speak against you when we're conducting investigations. Then you also think of additional applicable laws. I spoke about the fact that countries are also subject to international conventions like ECOWAS and the Malabo Convention. So regarding where data is moved to, you will have to consider whether or not they are also subject to other international laws, and then you input that there. And that's very important, because based on those laws, they will be obligated to actually carry out certain data protection measures, which would be good for data subjects, and it's something that we at the commission would be interested in. And then data subject grievance and redress. In this particular instance, you're supposed to explain what are the mechanisms you have in place to ensure that data subjects' rights are well exercised and enforced. Under the law, we have certain rights that data subjects are entitled to. We have the right to access. We have the right to not be subject to automated decision-making without any human oversight or involvement. We have the right to rectification. We have the right to object to processing. We have the right to restrict processing. So you have to show how your organization ensures that there are measures in place to actually implement these certain rights. And for example, in our right to access, have you provided opportunities for people to be able to write to you regarding what data you have about them? That can be through a form that they can fill. That can be through sending an email to certain addresses. That can be through certain mechanisms that have been put in place for them to be able to reach out to the organization to ask for their data. Regarding data deletion, have you put in measures in place to ensure that they can delete their data or they can rectify their data? So those are things that you would fill in here. The next one is data sovereignty considerations, and the cross-border issue comes in here again. One of the reasons why we have the cross-border law in Nigeria is that the government wants to ensure that if data is being moved out of Nigeria, it's done in a way that is safe. So as it's being moved, it's also secure. But in addition to that, our data is not moved to a place where that particular country can have access to our data and then use it for social engineering or create national security issues because they have access to that data. So it's the reason why I think the TikTok case is the reason why America was so investigated TikTok for a really long time, because they were worried that if TikTok is having like America data subjects data, then they have that much information and they can decide to use that against America, which is national security or social engineering. So these are things that countries have to consider, and these are things that you have to consider when you're moving data out of Nigeria, because those are things that we would actually really consider to ensure that as Nigeria data is moving out of the country, is done in a way that is safe, is secure, and is not subject to instances of national government surveillance by the country where data is being moved to. So these are the instances that you would consider, and that is what would inform your answers in this particular section. Then data subjects risks, so you would include the risks that we've already identified, like identity theft and fraud, algorithmic bias, unauthorized access, inability to alter data or delete your data. Those are certain risks that can occur. The next part has to do with principles of data processing. We have certain principles regarding how you process data under Section 24 of the Act. In this section, you would explain how you are complying with those principles. So for example, the principle to be transparent. Do you have privacy policies in place? Has Melo told data subjects that they'll be moving their data from on-prem to cloud service providers that are in another country that may not have adequate laws on data protection the way like Nigeria does? Has Melo satisfied the principle of data minimization? Are they dealing with data that is only needed for this particular person activity? Has Melo satisfied the principle of storage limitation? How do they store data? Are they storing it in accordance with the laws? Do they have storage policies? Do they have deletion policies? Do they have organizational policies? So you have to pick each principle and then describe how within this processing activity you are complying with each of the principles. So that's what will be there. The next one will now be what will be your recommendations for mitigation. One of the risks that we've already discussed in depth is cross-border data transfer. You can talk about a measure being an agreement that you put in place with country B to ensure that even if they don't have adequate laws in place, based on your agreement with CloudServe, you have put in contractual clauses that will ensure that data is well safeguarded. So clauses that will ensure that you use adequate security measures, clauses that will ensure that CloudServe provides ways for data servers to be able to exercise their rights, clauses that will ensure that there are places that data subjects can actually report to, clauses that will ensure that data is well secure and is used in a way that is responsible and safe. Then other mitigation measures that you can think of in this instance is just ensuring that there are adequate security measures in place to protect data. I spoke about if you want to use blockchain, you can also consider having the same data in a physical database that you can always cross-refer to the data in the blockchain. So that way, people can still exercise their rights to data deletion. That's one of the measures that you can put in place. Regarding artificial intelligence, one of the measures is to be transparent, tell data subjects about the risks that can occur. Another measure is to ensure that data is well safeguarded. Another measure is to ensure that your AI model is continually audited and that is trained on adequate data sets to ensure that you don't have bias. Another measure can be to ensure that you conduct an algorithmic bias assessment to ensure that your algorithm is not biased. So these are different measures that you can put in place, but these sort of measures are what you would put here to ensure that data is well protected. And then after doing this, you would then ensure that you actually implement these measures in place. Another measure can also be continuous auditing and monitoring of the processing activities. It can also be training your staff on data protection. It can also be putting in tools that have to do with data loss to ensure that if data is lost within that, when it's being migrated, there are ways to be able to recover this data. So these are the certain things that you put here after discussing extensively with the relevant groups. Then insurance and liability, you would indicate whether or not that you have insurance. these days we have cyber insurance to protect digital assets, and they also help in relation to how to manage data breach when it occurs. So if you have that particular measure in place, you can also put that as well in here. The last one is sandbox, and sandboxing is a situation where the government would allow you to test a particular product within a controlled environment within a limited time for you to be able to see how that product interacts with data subjects and the market, and for you to be able to identify the risks for that. And then the government will now provide guidance and direction to you as to how to mitigate against this risk. So at the Commission, we're currently drafting a sandbox policy. We just want it to be very robust before we issue it. And one thing we're trying to do now is we want to involve other regulatory agencies that would be involved in issuing out the relevant approvals for certain activities. So for example, now, if you're putting out a technology product that intends to maybe provide free, affordable healthcare to women in a certain region, and you're going to use technology using data public infrastructure and some artificial intelligence model, you will still, apart from the Commission's approval for data protection, you will still need NIDA's approval to an extent. You might need NIDCOM's approval to an extent for satellite data. So in that particular instance, you need different regulatory bodies to approve your certain activity. So what we're trying to do now is to get the relevant government agencies to also buy into the sandbox policy, so that when you as a tech company comes to us to review your products within that sandbox regime where it's controlled and you don't have to comply with any regulations because we're trying to test it out, you would be able to see not just privacy requirements, but also see other agencies' requirements, and they can guide you as well. So that way, when you're done with the testing of the product within that particular period, you are already regulatory compliant because you've already been put through the whole process and you know who to get the relevant approvals from. So if you would be using that for this particular product, or if you're already in the process, then you would include that sort of information in this section. Yes. And then the final part is the final assessment, where you have 3 different options. You can decide to go ahead with the processing because you believe that you have identified adequate measures to deal with the risks and you are able to implement it sufficiently and in a way that is effective. So you click go ahead. The next one is to modify data processing, and this happens where you believe that based on the exercise that you've conducted, you might actually need to modify your processing to ensure that you are in compliance with the law. Then you click modify. And then the last one is stop data processing. And that's where you, after going through this extreme and rigorous process, you believe that you're not privacy compliant or that the risks are too high for you to go ahead with this particular activity, then you can decide to stop data processing. And after that, we have provided a column for you to decide how frequently you actually review your DPIA. It can be monthly, it can be bi-monthly. It really depends on the context. And after that, you then would take this particular, after you're done with your DPIA, you would then ensure that all the measures in place that you have identified are actually being implemented. It's important to know that this is a process that, for it to be done very well, is quite rigorous. You will go through different departments and it will actually take time. You might take more than a month to conduct a comprehensive DPIA, but it's very, very important as it allows you to conduct your activities in a way that are compliant with the data protection laws in Nigeria. So thank you. Thank you very much. That's the end of the presentation.
Wow.
Let me know if you have any questions.
Yeah, I mean, there are a lot of questions, not even any question. There's a lot.
In fact, I was able to pick, I started picking from the ones that spilled over from when the scenario started. And believe me, this is a very, just like someone mentioned in the group, it's a full training course. It's a master class. And thank you so much for this opportunity. So what I'll do is I was getting the questions and I was merging them, especially the ones that were related. The first one is a number of people wanted to know if companies want to be compliant today, how willing is the Commission to assist them? Are there measures put in place by the commissions to help companies to become compliant? That's the first question we have.
Okay, Are there measures? Number one, we have licensed DPCUs. So we have licensed organizations to assist you with compliance. And if you look at the Commission's website, www.ndpc.gov.ng, if you go under services, if you click on it, you will see registered DPCUs. We have over 200. So you have a variety. I know that a lot of people actually complain about, oh, we don't have the resources to be able to hire a DPCO. But you have DPCOs that cater to smaller companies. You have DPCOs that cater to medium-sized companies, and you have DPCOs that cater to larger companies. So you have a variety of which to pick from. Once you consult a DPCO, they're able to ensure that your compliance is easy and smooth. It's just the way, this is the way I always describe it. You go to a lawyer for legal services. You go to a DPCO for data protection services. So that's one way that we have made it easy for you to comply. We are also we're quite accessible at the Commission. Like, I know that I always hear that comment a lot. So if you meet any of us, we're always ready to answer whatever questions you have. We're always ready to provide further guidance. You can email us at info@ndpc.gov.ng. We try our best to provide timely answers to your questions. Regarding companies that are struggling financially, there is a section on that guide where we say that if you're struggling financially, maybe you're going through bankruptcy or other issues and you're trying to comply, you can actually approach us and we can consider ways in which we can enable you to ensure that compliance is quite easy. Another step that we have taken is that when the initial guidance, I think it was a guidance that came out last year regarding registration of companies. I won't say the technical word because it's too long, of companies that are processing data. We got so much pushback. Oh, people don't have money to comply. So we decided that, and that there are other ways, that there are other compliance obligations. So by the time you actually lump everything up, it's too much. So we decided that for smaller companies, we call them ordinary high-level companies. Those are the ones that are processing less than 200 or 200 to 1,000 data subjects. We would not require you to file audit returns. You only need to register with the Commission every year, and it's just 10,000 naira. But you don't have to go through the rigorous audit process, which means that you don't have to hire a DPCO because you can only file your audit through DPCOs. Which means that you don't have to hire a DPCO to assist you with audits, because as a smaller company, you don't have to file audits. So those are different ways that we have tried to make compliance easy. I'm trying to think of what I think I said about 4 now. But like I said, we're very accessible. So if there are other issues you have, you can actually approach us, and then we can now consider bespoke methods to allow you to comply with us in a way that is affordable to an extent, yes. But there's certain obligations that still have to be complied with, regardless of how difficult the compliance is. So yes.
All right, thank you so much.
And I also just wanted to note that I wanted to note, and this is something I always say when I speak. We always advise that companies should not see compliance as just another regulatory burden, but actually see the advantage of compliance. When data subjects go to your website and they see NDPC compliance, it gives them that trust that I can actually trust this company with my data. So it's a business enabler, and it gives you a competitive edge. And then if you also think about the fact that if a data breach occurs and the Commission fines you or issues a remedial fee for you to pay, it's way more expensive than what you pay for compliance. So I always advise companies that if you think about the bigger picture, you will see how complying with data protection actually is a business enabler, as people will trust you and would want to do business with you. And in addition to that, you avoid reputational risks and paying huge fines. So those are things that you can consider. Those are things that you should please note when you complain about complying with the mission.
My last question, please. We are over and beyond our time, and we really have to allow Ms. Ibukun to go, because I know she took time out of a session she's attending to do this. So please.
All right, thank you so much. So I'll just lump them into one. For those that are asking how they can become DPOs or DPCOs, she has mentioned that the Commission has been training and continues to train. So please just try to keep updated and see their websites. I'm sure you'll get the information. But we have 2 questions that are likened to one. One said, can a person take action against their bank for mistakenly sending their information to another customer and exposing their data? Then another said, can someone take action against a landlord that takes a whole lot of information from the tenants, especially those that are not required?
Yes, you can. So these are general data protection breaches and issues. You can just file a complaint with the commission, but we'll still have to review it to ensure that your claim is meritorious. The first instance that you have mentioned, yes, they have an obligation to keep your data secure. If they cannot provide any legal justification for them sharing it with the other person. So if there's no legal basis to rely on, if there's no public interest, no contractual basis, no consent basis, no legitimate interest, then they have actually violated the law, and we can actually, on your behalf, investigate the bank for that. The second one as well already goes against the principle of data minimization. A landlord should not be taking more than they need for them to be able to process your data regarding your tenancy. So that's already a breach of data minimization. And if you file your action with us, we would then look at to see if it's meritorious. And if we believe it is, we would investigate the issue further and then let you know what the decision will be. So yes, you can. Those are 2 instances of violation of the law. Yes.
Thank you so much. Right. Thank you so much for that, Mr. Ibukunoluwa. We really have, I mean, the questions keep pouring in. A lot of, you have gingered, let me use the word gingered, you have gingered a lot of people. I mean, and there are a lot of very kind words for you in the comments. You've inspired a lot of people. I'm sure that people have to now. So, I mean, we generally don't do this, but I'm also very interested. So what's the easiest way to reach you? Can they follow you on IG, on LinkedIn, like your personal handle? And then please follow the Nigerian Data Protection Agency on the social media handles. I know they are on Twitter, that's X, on Instagram, on LinkedIn, and yes, all the other available channels. And please follow the MBSLP too. We are everywhere you are. We are MTN, everywhere you go, so you can find us. So in closing, I'm just going to take 2 announcements. First of all, once again, on behalf of the chair of the Tech and Law Committee of the MBSLP, thank you for staying this long. I mean, the participation has stayed very consistent. People are literally glued to their seats. For those who are asking for the recording, please go on the MBSLP YouTube channel. You will find the recording of a replay of this session and all previous sessions that we have had in the Tech and Law webinar series. You will find it there. Those who are asking for the slides, well, we'll need to ask, is Ms. Ibukun's intellectual property? We're going to have to ask her about that. But normally you will get our reports. We publish reports that will send to you via email after every webinar. So you get our reports. That's very important. You get that. And thank you so much once again. Yes, as regards CPD, if you check the chat box, we have posted the CPD points over and over again. In another 3 minutes or so, we'll be rounding this session up. Please note that the CPD point is only, the link is only active for the duration of this webinar. So if you were so attentive and you were literally very paying attention when Ms. Ibukun was speaking and you could not feel the link, so this is your time. You have another 2 minutes to fill the link. It is being reposted severally. After the webinar, the link will no longer be receiving responses. Very important, please. So please fill it. Please fill the link to claim your CPD points for the purpose of this webinar. Please fill the link. It is loading. Please kindly check your network or maybe your browser or something. But yes, the page is loading. The link is active. Please check. Catch a replay of this on the MBA YouTube, SLP YouTube channel. And for those who are not members of the MBA SLP who paid to be on this webinar, you can join the MBA SLP. I mean, it's not too late. You can see how much goodness you got from joining this session. This is just a taste of what you get every other time in every other webinar organized by the MBA SLP. So yes, please, the link is active. Please post the CPD link. And thank you so much once again, Ms. Ibukun. Thank you. It's been a very engaging session. Thank you, Huloma, for a very brilliant and wonderful moderation. Thank you so much. On behalf of the chair of the committee, I want to thank our distinguished participants who have stayed this long. Thank you so much. And we hope that you make the time to join us again in subsequent sessions. We do this every Thursday, all things being equal, There's no public holiday. If technology is our friend and everything goes well, we bring very interesting topics on the intersection between law and technology to you every Thursday, 2 p.m. It's usually supposed to be for an hour, 30 minutes, but today has been an exceptional one. So we made exceptions. Thank you so much. So while we are doing the countdown to round up and then close the webinar, and we are reposting the CPD link, I'll just allow Uloma to give a closing remark as the moderator of the session.
All right, thank you so much, everyone. It's been a very, very insightful session, even for those of us that thought we knew what we knew, but this has been a masterclass. So thank you so much, Ibuku, for this section. And thank you, learned SANs and other colleagues who made out time to be with us for the entire nearly 2 hours of this session. We had nearly 400 people participating, in fact, 380 something as at the last time I checked. So we're very, very grateful. And please join the SLP, especially the tech committee. We'll keep bringing you lots and lots of goodies like this in the near future. So thank you so very much.
Thank you, Uloma. So now the countdown officially begins. I will be reposting the CPD link. The admin will be reposting it too. And once in the next 2 minutes, please. This is very important because we don't want to have to receive inquiries about unclaimed CPD points and not receiving my CPD points. I could not fill the link, all of the inquiries. Please fill the link. We will be reposting it as I am doing an internal countdown inside my mind. So I am counting down, doing, please fill the link, please fill the link, fill the link, fill the link. Thank you for all the kind words. Thank you for joining us too. Please join the MBA SLP, join the Tech and Law Committee. Join us every Thursday for interesting and engaging and enlightening sessions like this. It's good value for your time, trust me. We deliver, we always deliver. Thank you, and bye-bye. Yes, if you have filled your CPD link, you can leave now because once it is 2 minutes after, sorry, yes. So counting down now. Counting down, 1. Okay, let me start from 10, countdown. 10, 10. Oh no, it's the Tech and Law Committee is a committee of the MBSLP. So just the MBSLP, mbslp.com. It's the same, .org, I think. Yeah, it's the same distance. So yeah, I'm counting down to, I'm already in 8, 7. Oh no, somebody said can't see the link. That's almost impossible. 7, 6, 5, 4, 3, 2, and 1. Thank you very much. So we hope to see you next week, Thursday. Make it a date with us. Thank you, everyone. And goodbye from us to you.
All right. Thank you, everyone. Bye.
All right. Bye-bye. Enjoy your event. Have a good time. Okay, our dear admin, quite frankly, I believe at this point you can end the meeting. We are justified. So you can end the meeting. Thank you so much. Yes, thank you so much. Thank you, Madam Fadekemi. Thank you for being our hosts always.